or take up a job.
So there should be more encouragement towards
litigating. When I say litigating, it doesn't mean that litigation in the normal case, because commercial contracts has to be litigated or commercial contracts has to be arbitrated. So anybody who studied, they have to be given special training, and today we lack in the courts is also a good lawyers who can represent commercial interest, and judges also, because judges are coming from a totally different background, and sitting in judgment over a commercial contract may be something very cumbersome for them. And that's why very recently the Supreme Court has said that the high courts and the lower courts have a tendency to either push it up without deciding a commercial contract, or push it down, let it go back and decide. So I think there should be a segregation. This is my thinking on the legal education. Today I am not satisfied with the legal education which is given. The legal education is glorified class. You have to get into any corporate, or you have to get into any law firm, be there for the rest of your life.
Sir, anything you have to say on the Bar Council examination which they have recently started, and the first set of examination has taken place, and post that, are we pushing ourselves towards a step towards creating a better lot of advocates by bar examination?
Yeah, I think this is not something new. I myself, when I joined, the examinations were not there, so I could enroll myself and become an advocate. And today what happens is, prior to that, there was my father, he had to do, before becoming an advocate, he had to pass his Bar Council examination. And today, it is a sequel to my earlier answer, which says is that I welcome the Bar Council examination, and if only those who pass that examination should be allowed to practice in the court. And because that gives them a little more of interest as to practice in a court of law. So therefore, two types of lawyers we should create. Those who do not want to practice, they need not be attempting this kind of examination, and still they should be allowed to join a law firm and advisory capacity, or even in a in-house legal firm, in-house legal in a company, but they will not be able to represent their case in a court. And those who have passed this examination, definitely they should be allowed to practice in a court. So that will, the real people who are interested in litigation and who are in a position to litigate before the court, their interest will be protected. Otherwise it is an overcrowded field where everybody becoming an advocate after 5 years or 3 years of education. I think there needs to be a little bit of filtering on that, because with lots and lots of colleges saying that global education is being imparted, I think it should be, I welcome the concept of examination for those who really want to take a practice.
Very well said, sir. Talking of the banking sector that is battling rising NPAs, as the legal head of a leading bank, how do you ensure that the bank's interests are secured to the maximum extent possible?
I think there is a background to this. The rising NPAs are a reason why the government of India passed a special legislation called the SURFACE Act in 2002. After much dilly-dallying and hassles and everything, the Supreme Court has come out and said that the said act is valid, and it is not ultra vires of the Constitution. But the sad fact is that even after that, the banks were very happy, because without the intervention of the court, you can take on a secured credit, secured asset, and then sell it in the capacity as a secured creditor. But still, what happens is, still the courts at the drop of a hat are interfering in such procedure. So I think that act, if it is implemented without the intervention of the court, and if the courts are becoming a little more strict not to accept such whimsical petitions and others, especially the lower courts. I would say the lower courts like DRT and the civil courts, they are interfering without understanding the entire gambit of that law. And if that comes to a certain extent, it can be solved. The second part of the question is, see, as a legal chief of a bank, when I am entering into a contract, I always think that what happens if it becomes an NPA. So I have to protect the interest of the bank by putting adequate safeguards and adequate clauses which I feel would stand the test of law if it is tested by a third party like an umpire, be it an arbitrator or be it in a court of law. So it all depends on the drafting, where you have to have a clear-cut idea of what you are writing, and it should not be ambiguous, and it should not be given to more than one interpretation, and if that be the case, I think to a great extent we can solve. But I should also confess that there is no foolproof method by which you can say one agreement drafted by one person or any agreement drafted by any lawyer or an in-house counsel is safe and the other one is bad, because it all depends on the whims and fancies of the courts as also on the circumstances. So therefore, what my suggestion is that when drafting the contracts, as an in-house counsel, we should understand the business, what is meant, and therefore the drafting should be very clear. If that be the case, we can win a lot of cases. And I always welcome settlement, because settlement is something which, as a lawyer, when it comes to me, I always welcome, because the raw material of the bank is money. So I don't want to litigate for another 20 years and say that I won the case by the time the security has got no value. So therefore, I feel that if a settlement, fair settlement comes, as a legal person, we should not stand on technicalities and we should go with the business department and get it settled. That's what my...
Great, sir. The subprime mortgage crisis emanating from the banking sector in the US was blamed for the onset of global recession 2 years back. Do you think our banks in India are cautious and have enough legal safeguards to avoid a US mortgage crisis?
I think when this US mortgage issue came, everybody in India got panicky, but India did not have any kind of panic situation. One, I would thank Reserve Bank of India, because the Reserve Bank of India has adequately protected all the banks in India. We have a tough regulator. Sometimes we also feel that regulator is overstepping, but I thank them. Because of them, all our banks survive. As far as the subprime mortgage is concerned, my answer is very simple. In India, nobody would like their house to be taken away by the bank and sold in public auction or a private auction, because that is a stigma in their life, the whole life. So therefore, once such a condition, such banks attach, or banks come for payment, and definitely by either they borrow, steal, or whatever it is, they pay it off. Otherwise, they'll quietly sell it by themselves and pay it off, rather than the bank taking it over and selling it. Not that the banks have not taken over and sold it, in very rare cases. So the ethics or the culture of India, which says that house is something sacred to each and every one, is also a reason for the subprime crisis which happened in America not to come here. I have never felt any such thing. In fact, during that time, it was in India we saw a lot of a boost in the purchase of mortgage-backed houses, and even today it continues in spite of the higher interest rates. So I don't think that kind of a subprime crisis will arise in India, unless otherwise, we are pushed to a big recession, which I don't think is going to happen in India.
Okay. Thank you so much, sir, for sharing your thoughts, and thanks.
Thank you very much, and thank you very much to Legal Era for coming and interviewing me and giving me an opportunity. I wish Legal Era all the best. Thank you very much.